Hi everybody, welcome back to this series, concepts that matter for legal reasoning for your examinations. In the last video, we have seen the basics of tort, a few principles we had learned. And if anybody is watching this video for the first time or meeting me for the first time, then I would suggest that after you watch this video, also go back to the previous one to understand the entire concept in a better way. All right. So I welcome you all once again. I am Bhavtosh, Chief Mentor Law, CLAT Possible. And today we are going to discuss another concept that really matters for your examination, which is critical. Okay. So in tort, there are certain defenses, and those defenses are used by the defendant party. Defendant party कौन होता है? ठीक है, अगर A has filed a case against B, तो B जो होता है वो defendant कहलाता है. That means A has complained something about B. So B is the respondent. He has to basically respond or defend himself. Now when he will go to the court to defend himself, क्योंकि A ने तो शिकायत की है, अभी B को अगर अपने आप को बचाना है, he wants to save his liability, तो उसको कुछ ग्राउंड्स यूज करने पड़ेंगे, कुछ पॉइंट उसको यूज करने पड़ेंगे, ठीक है, जिससे उसकी लाइबिलिटी बच सकती है. ही माइट अवॉइड हिज लाइबिलिटी. सो उसमें उन 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 ग्राउंड्स को हम बोलते हैं डिफेंसेस. ठीक है, ग्राउंड्स दैट सेव बी फ्रॉम लीगल लाइबिलिटी. अब ऐसे बहुत सारे ग्राउंड्स होते हैं, बट इन टुडेज सेशन वी आर टेकिंग वन पर्टिकुलर ग्राउंड विच इज वीएनएफआई. अगर फुल फॉर्म देखें तो वॉलेंटाइन नॉन फिट इंजूरिया, शॉर्ट में बोल सकते हैं वीएनएफआई. क्या होता है वीएनएफआई? आई वांट यू टू फर्स्ट रीड द डेफिनेशन, and if you want you can write the essentials, but I want you to definitely read the definition twice or thrice to fully understand it. It says where a person engages in an event. अब where a person को हम मान लेते हैं victim. इसको इस तरीके से पढ़ना है, where a victim engages in an event accepting and being aware of the risk. Being aware, that is the first condition inherent in that event, then they cannot later complain of or seek compensation for an injury suffered during the event. क्या बात चल रही है कि one Mr. A, what he does is he goes for an adventurous sport. Adventurous sport में let's say paragliding, okay, or bungee jumping. He goes for bungee jumping. Now bungee jumping as a sport comes with some inherent risk. What is the risk? That you might suffer some bodily injury during it, okay, or you might even suffer shock. You may be very scared, among others. It may go wrong. Okay, many things can happen during bungee jumping. So where Mr. A decides to go for a bungee jumping, he was not able to handle it. He suffered a heart attack mid-air and dies. Now his family wants to sue the company that performed the bungee jumping. Let's say that's the company. Now the company is the defendant. Defendant मतलब जिसके ऊपर केस हुआ है, जिसके ऊपर सूट फाइल हुआ है. तो यहाँ पे एक की जो फैमिली होगी वो कहलाएगी प्लेंटिफ, और कंपनी इज द डिफेंडेंट. तो प्लेंटिफ बोल रहा है कि कंपनी से कॉम्पनसेशन रिकवर करना है कि मिस्टर ए वाज एंगेज्ड इन बंजी जंपिंग विद योर कंपनी एंड ही डाइड मिड एयर बिकॉज ऑफ हार्ट अटैक, देन यू आर लायबल बिकॉज ही वाज टू स्कैर्ड. ओके, नाउ इन दिस केस व्हाट विल हैपन, द कंपनी कैन टेक अ सिंपल डिफेंस ऑफ वीएनएफआई. वीएनएफआई इज वॉलंटरली टेकिंग रिस्क. कंपनी क्या बोलेगी? कंपनी बेसिकली इसके ऊपर बर्डन शिफ्ट कर देगी. कंपनी बोलेगी दैट मिस्टर ए वाज अवेयर ऑफ दिस रिस्क. कौन सी रिस्क? दैट बंजी जंपिंग के अंदर, इस एडवेंचरस स्पोर्ट के अंदर जो इनहेरेंट रिस्क है वो ए को पहले से पता थी. ठीक है, हमने बता दी थी और उसको पता भी थी. और डिस्पाइट नोइंग अबाउट दीज रिस्क, ही वाज अवेयर ऑफ द रिस्क. डिस्पाइट बीइंग अवेयर ऑफ द रिस्क, ही चोज टू गो अहेड with it. He decided to go ahead with it, okay, without any pressure from anybody, without any fraud, cheating, or without any kind of insistence from anybody. He voluntarily wanted to do it. Voluntarily wanted to do it. So two things are there. First thing is he was aware of it. What is the risk? What can possibly happen? And he decided to go for it voluntarily on his own. तो इसका मतलब क्या हुआ कि nobody should be liable for this injury. Nobody should be liable for this kind of injury. The injury that he has suffered out of his free will, right? तो इसलिए ये कॉन्सेप्ट यहां पर अप्लाई होगा. And in this case, the company will win the case. A's family will lose the case. How will they lose it? Because of the defense that the company is successfully able to take in its favor. Essentials. Now we can break it down. Harm suffered out of an event to the plaintiff. Plaintiff कौन हुआ यहाँ पे? A. ठीक है, उसको पता था इसके बारे में ऑफ द पॉसिबिलिटी. गारंटी नहीं चाहिए, पॉसिबिलिटी चाहिए कि मतलब हो सकता है. दैट इज इनफ. एंड ही वॉलंटरली गिव कंसेंट टू द सफरिंग ऑफ सच हार्म. Voluntarily gave consent to the suffering of such. Clearly a case where plaintiff will lose. What if it so happens that the company which was operating this sport of bungee jumping, they were negligent on their part. There was some fault in their system, there was some fault in the rope, and they did not operate it carefully, because of which the rope breaks and now the plaintiff falls and suffers a grievous injury. Assuming that be the case, now the situation will change, because he was not aware of this possibility that the company will be careless, first of all. And even if he was aware that company can be careless, can be negligent, he never gave consent to the suffering of such harm. He never gave consent to the suffering of such harm, the harm which is caused by the negligence of the company. Which harm am I talking about? I'm talking about the harm which has been caused because of the negligence of the company. इसके लिए उसने कंसेंट नहीं दिया था. ठीक है. सो एक और चीज है ये समझने वाली, that when do you not give consent for harm? I repeat the question. When do you not give consent for the harm? The answer is negligence of defendant. We never give consent for negligence of defendant. और negligence कैसे पता चलेगी? Something which is not a natural consequence. Something which is not a natural consequence. In other words, negligence can also be said to be carelessness, right? Lack of care. Okay, so if the operator was negligent, the plaintiff will be able to recover compensation. Fine, let's go ahead. Now look at this question. Try to solve this question. So clearly, again, it's he was one of the spectators at a Formula 1 car race. It's a car race, understand? The car race. How does it happen? Let's say there's a circuit, there's a track, and the race is taking place somewhere here, and then the audience are here, spectators are here. So during the car race, when it happens, you have to assume what all can go wrong. What all can go wrong as a part of natural consequence of the event. If there is natural consequence which can likely happen, जिसके होने की possibility है, in that case the company should not be liable. But if there was any negligence, तो फिर liability arise हो सकती है. Now look at the question and try to solve it. Clearly it is mentioned that during the race there was a collision between two cars. बिल्कुल, it's a natural possibility. Racing event है तो collision हो ही सकता है, and because of which one of the car was thrown away amidst spectators, मतलब यहाँ पे कहीं पर एक्सीडेंट हुआ होगा and the car was thrown into spectators. Very very natural consequence. It's a very it's a high possibility consequence. ठीक है, बिकॉज कार रेस है, स्पीड में कार्स उतनी है, और स्पीड में अगर कॉलिजन होगा विच इज नेचुरल, तो जो कार है वो इट कैन बी थ्रोन अवे, it can it can swing in the air, it can fly in the air, go away to the spectators. Clearly that becomes the reason why the company shall not be liable. Okay, shall the company will not be liable के दो ही ऑप्शंस हैं, बी और सी, तो हमें ए ऑप्शन काट देना है. ऑल्सो वी कैन एलिमिनेट ऑप्शन डी, बिकॉज कंपनी तो लाइबल नहीं होगी, बिकॉज एनीबडी हु कम्स टू वॉच द रेस should know that what all can possibly naturally go wrong, even without the negligence of the company, right? So अब ऑप्शन बी और सी में से जब एक चूज करना है, तो ऑप्शन बी में लिखा है कि कंपनी लायबल नहीं होगी क्योंकि वो खुद अपनी मर्जी से रेस देखने आया था. दिस इज अलाइंड विद द प्रिंसिपल. ये जो ऑप्शन है ये प्रिंसिपल से अलाइंड होता है. सो दिस कुड बी एन आंसर, बट लेट्स नॉट रश इनटू इट. लेट्स स्टिल लुक फॉर बेटर ऑप्शंस. ऑप्शन सी बोलता है कंपनी लायबल नहीं होगी बिकॉज द कोलिजन वाज बियॉन्ड द कंट्रोल. अब ये बात सही है, इट्स अ करेक्ट स्टेटमेंट, बट it is not based on the principle. And if it is not based on the principle, we shall not choose it. Option C cannot become your answer because it is not based on the principle, even though factually, logically it might sound correct. ठीक है, तो इसको हटा देते हैं. ऑप्शन बी हमारा फाइनल आंसर हो जाएगा. We have to choose an answer which is based on principle, which aligns with the text of law given in the principle. So in your exam, you not only have to choose the right answer, but also the right logic, which is based on the given law. ये बहुत जरूरी चीज है. You can avoid a lot of mistakes by simply following this rule for your exam. Let's do one more question. Here is it. The VNFI, based on the VNFI. So the same principle, when a person voluntarily agrees to suffer some harm, he is not allowed to complain for that. Simple VNFI principle. देखो ये आपको अलग अलग वर्ड्स में दिया जा सकता है. Different language may be used, different words may be used, but you don't have to be confused. As long as you are able to understand the true meaning and intent behind a certain principle, then there is no need to be confused. So what is happening here is this woman noticed development of a painful lump. She went to a doctor and the doctor suggested for a surgery. यहाँ तक कोई दिक्कत नहीं है. During the surgery, doctor believes, although not on the firm grounds, not very sure, flimsy reasons to believe that such lump may develop in the future. It is just a remote possibility. Okay, remote possibility. So she removed the uterus during surgery. Now, first of all, removal of uterus was not consented. Removal of uterus was not consented because she had visited the doctor for treatment of lump in the breast, not any treatment related to the uterus. So इसके लिए कोई consent नहीं था. ठीक है, it's like a patient visits a doctor for chemotherapy and the doctor performs a heart surgery. So for heart surgery there is no consent. Okay, unless there is no necessity, unless there is any necessity. अगर कोई emergency है, कोई urgency है, कोई necessity है, then definitely the doctor can perform an operation even without your consent. But without any necessity or emergency, no surgery can be performed without your consent if you're the patient. Okay, based on that understanding, the surgery of uterus was not consented for. But in actuality, uterus would not have caused the lump. Now, also, it is mentioned it would not have caused the lump, and that means it was not necessary. What was not necessary? The removal of uterus was not necessary. ना तो नेसेसरी है, ना कंसेंट दिया था, और ना ही प्लेंटिफ को पता था कि सच सर्जरी माइट बी कंडक्टेड बाय द डॉक्टर. ठीक है, द प्लेंटिफ कम्स टू नो ओनली आफ्टर इट. Then she filed a case against the doctor for removing the uterus, which is not consented and which is also without her knowledge. Very good. Now the doctor tries to plead the defense of Volenti Non Fit Injuria. डॉक्टर बोल रहा है that the plaintiff had given consent. मतलब डॉक्टर क्या बोलना चाह रहा है? That only because the plaintiff had visited the doctor for one kind of surgery, this is what the doctor is trying to say. You have to examine if his statement is correct or not. He is making an argument that only because the plaintiff visited him for a surgery, that meant that the plaintiff had given consent for any kind of surgery, any kind of damage, any kind of event during the surgery. But that's not true. He had come only for a specific kind of surgery, not for the different course of action for the other kind of surgery. Clearly, so the doctor has to be liable. The doctor has to be liable. Not liable वाले options काट देने हैं. Option C बोलता है is liable as the patient gave consent only for removal of lump, not of the uterus. Absolutely correct option. Absolutely correct option. See, consent is not unlimited. Consent is limited. Okay, consent is limited to things that have been told to you, things that are in your knowledge, things which have been brought into your notice. Only for that. If anything happens beyond what you know, beyond what you are aware of, then you can still hold the other person, that is the defendant, liable in such cases, right? So I hope the concept is clear to you. Let me give you a short recap of what it is. Whenever the plaintiff is aware of a risk and he takes it voluntarily without any pressure, without any force, then he cannot complain of any harm that he suffers out of such an event. But it is essential for this that he must know what is the risk, and he must give consent to suffer harm out of such risk. But in case the defendant is negligent or careless, then the plaintiff does not give any consent, right? First of all. Secondly, the consent given by plaintiff is limited to the risk that he knows. Okay, it cannot go beyond what he does not know. So there is no unlimited consent. There is no limitless consent. It's always limited. It's always within a set boundary of the awareness. Okay, so I hope this concept is clear. Concept related to VNFI should be clear to all of you. It's a very important concept. Like I said, a lot of questions in the past have come up from this concept, both in CLAT and AILET as well, and also in the non-NLU examinations. So yeah, so it's an important concept. If you have any question, post that in the comment box, and I will answer that for sure. Okay, so that is it for today. And if you like the session, please hit the like button, share it among your friends or group so that they can also benefit. And if you have not already subscribed the channel, please do that right now, because we will keep coming up with more such concepts, with more such provisions of law, interesting and relevant provisions of law that really matter for your examination. Thank you so much.